Good afternoon, everybody. My name is Rachel. We are going to be getting started here with the December Homeline New Law webinar series in just a couple of minutes. I've got it just coming up on 1:30 now, so we'll give folks a little bit, a minute or two to get logged in here. But again, this is going to be the December webinar on evictions. And so if that is what you've been waiting around for, you are in the right spot. And again, we'll get started in just another minute or so. Okay, I'm seeing that the flow of people is starting to slow down a little bit as people are joining. Once again, this is the Homeline December webinar. We're going to be covering evictions this month. And so if that is the thing that you have been waiting for, you are in the right place. So we will go ahead and get started. We've got a lot of content here today. I'm seeing by my clock that it is 1:31. So we can go ahead and get started. I've got a couple of housekeeping things here first before we continue, get into the meat of everything. We are going to be joined by attorney Larry McDonough, who is going to give us all sorts of information here in about evictions and the new laws that are coming up. So here we go. So what is Homeline? Just in case you haven't been with us before, um, we are a nonprofit that works across the state, specifically helping tenants kind of navigate what their rights are under Minnesota tenant landlord law. We've been around since 1992, and in those 33 or 31 years, we have served over 300,000 renters. We do offer our services in 4 languages: Somali, Hmong, Spanish, and English, as well as an email and attorney option as well. So our phone number is there. It's a toll-free hotline. Anyone in the state can call it, or one of those language lines if that's the preferred language of you. And so this is still ongoing. I know that we've talked about this being the new laws for 2024, but this series is still going to be continuing on come January. January is going to be a little bit different than what we've been doing so far in 2023 because we are going to be covering renters credits, specifically CRPs is another term firm you may be more familiar with. But in January, we're going to be joined by the Minnesota Department of Revenue and the Minnesota Budget Project to kind of discuss what the changes are that were passed in 2023, but a lot of those changes are not going to actually be in effect until when folks are starting to file their 2024 or taxes in 2024 or for 2024. So this is really it's not tax advice. It's not like accountants telling you how to do things, but it is going to be walking through what the changes are. And it's going to be, I think, it's going to be a little bit different than what we've been doing here thus far. So especially if you are a landlord or a landlord attorney, there's going to be some big changes coming down the pipeline for how you deal with CRPs and things like that and how you file them. So this will be a really great resource for y'all to kind of get a heads up on that right away. So again, that's what's coming up in January, January 17th. The registration for that is available now. And just for today's session, we are going to be applying for CLE credits, should be 1.5 standard CLE credits, so long as we take up our 90 minutes. The session is being recorded and it's going to be available on our website within a couple of days, along with a PDF of the slides. And then if you do have questions, we love questions, we encourage questions. Please feel free to ask them, but if you could use the Q&A function at the bottom of your screen and your Zoom screen instead of using the chat. I will be posting a lot of things like links and stuff in the chat, and so your questions just get lost. I miss them. I feel badly about it, and but it is what it is. So please use that Q&A function at the bottom of the screen if you have questions. Now, we also had some pre-submitted questions that came through, and so we'll be covering those first, and then we'll go through the Q&A questions that come through during the webinar today. Okay, that is enough out of me. I would like to introduce, again, Mr. Larry McDonough. He is a policy attorney here at Homeline, along with the landlord tenant chapter of law guru. He's been doing this for several decades at this point. So he is definitely the expert in all this. And he is going to be taking us through the very detailed updates of all the things that are happening with evictions come, gosh, just about 2 weeks from now. So yeah, it's coming up real quick. All right. Take it away,
Okay.
Larry.
All right, thanks, Rachel. And so besides working with Rachel today, I'm joined today by my Victorian Santa Kai, since holidays are coming up. So whatever I don't know, Santa will probably help me out and we'll get it all figured out. So yeah, let's get started here. Next slide, please. So I'm going to be talking about specific laws related to evictions today, but I wanted you to know where you can find all of the new laws. Most of the laws affecting landlords and tenants are in Chapter 52 of the session laws. There also are some laws related to landlords and tenants in the cannabis law, which is Chapter 63. And there's a little bit of discussion of sober houses and their interaction with landlord-tenant law in Chapter 61. So with these slides that you'll be able to get after the seminar, if you ever see a link in here, if you select that link, it'll take you right to the source material. So these links would take you to those laws. Now you can also look at the laws, the statute laws, but that's a little confusing right now because most of these laws, at least in the landlord-tenant area, have not gone into effect yet. We'll talk about some that have, but most of them haven't. They go into effect January 1. But if you go to the revisor's website and look at 504B, you'll see the laws as they will exist on January 1. And so it's important for everyone to know that almost everything we're going to talk about today is not in effect today. It'll be in effect in just a couple of weeks. So keep that in mind whenever you're looking at the revisor's website. If you look at Westlaw, I was checking the other day, and Westlaw for different laws will say, here's the law right now, and here's the law that's going to be effective January 1. So really important to keep that straight. Okay, next slide, please. Okay, so the first thing we're going to talk about is right to counsel in public housing breach of lease cases. So I've got a little summary here because I know there have been some questions that have come up about this law. And again, the link on this page would take you directly to the session law. And so it's a new statute, 504B268. It's patterned off of other right to counsel statutes that we have in Minnesota, like guardianship, commitment, quarantine, things like that. And so the process is a person who's covered by a right to counsel law has the right to request that the court appoint an attorney for free to represent that person if that person doesn't have an attorney. So where this intersects with landlord-tenant laws, it only applies public housing and only to breach of lease cases. So that does not apply to rent cases. And it also does not apply to other subsidized housing programs. And I know some people have asked questions about that. Public housing is not defined in this statute, and it's not defined in other Minnesota statutes that discuss public housing. public housing really is a term of art in landlord-tenant law. It's housing that is owned by the government, usually a local government like a public housing authority or a housing and redevelopment authority. And they own the property, they get subsidies from HUD to manage the property. When tenants move in, if the tenant moves out of the property, the tenant leaves that subsidy behind. So that's different than a Section 8 voucher program. This really applies to a small number of cases. If you are representing a public housing authority, then it applies to you in a breach of lease case. If you are an attorney not representing a public housing authority and you have a case involving subsidized housing, it's not going to apply to you. If you're a landlord or a management agent, same thing. If it's public housing and breach of lease, it applies. If it's subsidized housing, it doesn't. If it's private housing, it doesn't. And again, if it's public housing, but something other than breach of lease, like non-payment of rent, it doesn't apply. What the statute does, it has some required language for a public housing authority to put in the complaint, alerting the tenant that the tenant has the right to request court-appointed counsel. The court is also supposed to make an inquiry with the tenant about whether the tenant has counsel. And there are provisions regarding attorney qualifications and compensation. Now, this is one of the few landlord-tenant statutes that went into effect on August 1, 2023. So now I just want to show you the exact language in the statute. And the slides today, there are a lot of slides here, and they might look kind of dense in terms of content. That's kind of how I like to do slides. I like to have a lot of content there, even if I don't go through all that content, so that when you get the slides, you'll have that kind of detail there. So what I've done is I've throughout these slides have pasted in the actual language from the session laws. And so where there's underlining, that's where we have new laws. And where there isn't underlining, that's the existing law that's unchanged. If there's a cross out, that's what's being deleted in the new law. Since it's a brand new law, everything is underlined. So again, it's a defendant in a public housing eviction case alleging breach of lease. If that person is not able to obtain counsel, then that person has a right to appointment. Now, a lot of, I wouldn't say a lot, but a number of tenants in public housing may already have an attorney representing them in an eviction case. And so then the court wouldn't make an appointment. But there may be times when either that person didn't know about legal aid, or legal aid might have a conflict, or legal aid doesn't have capacity where this might come into play. There's a compensation section here, but it's up to the district courts to figure out what their compensation plan is going to be for attorneys. It ranges around the state from about $75 an hour to maybe about $125 an hour. And the courts basically put together their plan each year, as they do in other types of right to counsel. Qualifications there. You can see what the qualifications there. You either have to have 2 years experience doing public housing cases, you have to go to training or be supervised by an attorney who meets the minimum qualifications under clause 1 or 2. This is probably not going to apply to a lot of tenants. In 2016, a review of publicly available court data showed that this would have applied to about 60 cases statewide, with the bulk of the cases being in the larger counties like Hennepin County, Ramsey County, Olmsted County, and quite a few counties not having any cases where this would apply. Okay, next slide. So now we're going to go into all the other eviction changes. So first of all, the effective date, almost everything we're going to discuss now is effective on January 1. I'll make a notation where that is different. Next slide. Okay, so first I'm going to talk about combined claims. And essentially what I did is I mostly took these changes in order of how they're presented in the chapter. So it might seem a little random to you, but hopefully you'll still be able to follow. So a number of changes were made in the laws to change the existing practice of ordering tenants to pay disputed rent into court. So even though my feeling has been that the case law and the statutes and the rules have not required judicial officers to have a tenant pay past rent into court, put on a case that they don't owe the rent. There have been a number of judges and referees over the years that have just done that. I think there's a little bit of just an urban myth out there that that's what was in the Fritz case, but it wasn't in the Fritz case. What the Fritz case talked about is if there's going to be a delay kind of going down the road, then the court might want to have the tenant pay rent into court as it comes due. So anyway, there's several changes in the laws in different kind of fact situations that we're going to have the courts looking forward in terms of paying rent into court, but not backwards. And so this is one of them. It deletes the language here at the bottom about the tenant having to pay rent into court to defend a case involving combined claims of material breach and non-payment of rent. Next slide. So there was a change in the redemption statute, and this provides that redemption. So redemption, to back up, is the concept where an eviction case for non-payment of rent by statute is a demand for the rent, and the tenant has the right to comply with that demand and pay the rent and not be evicted. And the redemption statute talks about the tenant paying whatever the court orders by the deadline the court gives. And it doesn't say anything about form of payment or guarantee. Now, there are a number of agencies that can guarantee payment of funds before they can actually issue the funds. And so what this change does is it allows that the tenant may redeem by obtaining a written guarantee from either a government agency or a nonprofit that administers a rental assistance program and has sufficient funds available and guarantees that funds would be provided to the landlord. Next slide, please. Okay, there was a fairly big change in 504B321, and the statute is presently called and will continue to be called complaint and summons. But the real change that happened here is a new notice that landlords will be required to issue before they file an eviction case for non-payment of rent. And I know this has been discussed in other seminars that we've done this year, but this is a pretty big change, and so I think it's important for us to cover it today. So next slide, please. So part of this will be fairly quick, and then part of it will be a little bit longer. So this is simply saying that if the landlord is required to give the written notice under subdivision 1A, which we'll get to in a moment, they need to attach it to the complaint. And if the landlord doesn't, the court will dismiss the case. Next slide. Okay, so this is kind of the meat of the big change here is the written notice. So in a non-payment of rent case, the landlord must provide written notice. And first we get into the contents of the notice. And it's with some detail. Total amount due, specific accounting of the amount due from unpaid rent, late fees and other charges, the lease, name and address of the person authorized to receive rent and fees, and a couple of statements regarding either getting legal help or financial help, and also a statement that you essentially have 14 days to comply with this. Now, I've been representing, mostly tenants, but I've also represented landlords over the years. I've also been a landlord off and on over the last almost 40 years. And so I can look at this stuff from both sides of the equation. If I were a landlord doing this, I would have a fairly detailed document. It wouldn't necessarily be a ledger, but I would have something that says, here's the amount of rent due, and then I would break it down. I'd break it down by months. So let's say the tenant owes me rent for November, let's say December and November. And so I'm giving, maybe I didn't get around to giving the notice last month, but I'm giving the notice now. And I would encourage landlords to go ahead and give that notice early. There isn't any reason why you have to wait, a month and a half for the rent. If giving the notice does not require you to file an eviction case, but you need to have done it to file an eviction case. And it might start a conversation going with the tenant about, can the tenant get some financial assistance, either from the government, or from a nonprofit, or a family member or a friend? Is the apartment simply unaffordable and the tenant says, let's make a plan to move? If the tenant has some complaints about habitability or something else, maybe it tees up that conversation as well. But let's say that I'm filing a case for 2 months rent. I would have the total amount due. I'd have the amount from each month. I'd have the amount that I've assigned to late fees that are limited to 8% of what has not been paid in rent. If there are other charges due, like utilities or other fees under the lease, include those as well. So I would be detailed. This is not a place to kind of hide the cards a little bit. This would be a place to be fully transparent, because the risk on the landlord side of the equation is if you're not fully transparent, maybe your case gets dismissed. On the tenant side of the equation, the transparency helps the tenant figure out exactly what's due, the time frame for dealing with it, and starts the tenant thinking about, what can I do to either comply with the demand for the rent or to figure out a plan to leave. Next slide. Okay, I'm just going to move something on my screen here a little bit. Okay, so the notice has to be delivered either personally or by first-class mail to the tenant at the address. Okay, and I've heard some conversation about, well, does personally mean just personally drop it off, or does it mean give it to a person? And generally in the law, the concept of delivering something personally is delivering it to a person, not just putting it on a door. Now, I know this law doesn't specifically say that, but again, on the landlord side, I would say this is not a place to, try to find what are the little holes here and there in the law. If I were advising a landlord, I'd say, you or your agent go by to the property, see if you can find the tenant at home. If so, hand it over. If not, then mail it by first-class mail. Gotten questions, should it be return receipt? That's really up to you. If you and your tenant have a checkered history about getting along, then maybe you do it by receipt mail. If not, then I think first-class mail would be adequate. When I was a landlord, I generally sent things by first-class mail. And then next, if the tenant doesn't correct the deficiency, then the landlord can then file an eviction action based on non-payment of rent. Next slide. I think a really important aspect of this new these new changes is that this type of notice that we're giving that we just discussed constitutes verification of an emergency for the purposes of obtaining emergency assistance. There have been complaints over the years in some counties that emergency assistance doesn't move very quickly, that it requires a lot of documentation before it issues money. And the idea here is that this notice would qualify as a verification of the emergency, so that the agency would not have to then say, well, go get me some statement or some ledger from the landlord. So I think this is a good change, I think, for both tenants and landlords. I think in general, landlords and tenants in some counties have been dissatisfied with the speed in which emergency assistance operates. That's not all counties, but I've certainly heard those complaints. And when I did legal aid work, I had some of those complaints of my own. Next slide. And just before I start on this slide, I've been asked, so what do I think the effect of what we just discussed is going to be on the number of eviction cases? And that's hard to predict. We'll see what happens. So it's certainly going to slow down a landlord who wants to file the eviction case on the 2nd of the month. Okay? When I was a landlord, I generally didn't file on the second of the month. I would have, now granted, I didn't have a lot of properties, but I would communicate with the tenant and try to figure out, is this something that we can resolve? Sometimes I would send a letter saying, this is what's going on, and that would spark a conversation, even though I didn't have to send the letter. I think the sending of the letter, the notice, is actually going to lead to less eviction cases, because I think it's going to start both the thinking in the tenant, can I make this work? Can I get help? Do I need to move? It's going to start a conversation, I think, with the landlord about those things. And if there's an agreement about the tenant moving or the tenant getting some assistance, then there isn't an eviction. So I think it's actually going to lead to less evictions. Another reason why I think it's going to lead to less evictions is I think we're going to see a quicker response from emergency assistance when the tenant goes there and says, I've got one of these notices, I'm low income, I think I qualify for emergency assistance. Here's the information that verifies the emergency. So we'll have to see what happens, but that is my belief that it's not going to eliminate eviction cases, non-payment of rent, but I think we're going to see a dip. Then we'll just have to see. Okay, on this slide, there was a change in basically what constitutes allegations for an expedited hearing. Expedited hearings are, as you can see, for kind of serious endangerment issues now, serious damage issues. It was a little less, I think, clear in the past when you could do an expedited hearing. When I've advised landlords about them, I haven't been really excited about doing an expedited hearing. I mean, I'm comfortable doing them, but it doesn't move the case that much faster. And the window for serving the court papers in an expedited case is very, very narrow. And so I don't think there's a big advantage to filing the case. And you then have this very narrow window for service of process. But anyway, these are the changes in that we see a very small number of expedited procedure cases. Next slide. So occasionally Santa and I, she started late here. Santa helped me out here. I'll look down at my phone here because when I'm doing a Zoom presentation, I can't see the time from my computer and I want to make sure I stay on time. Okay, continuing on with the statute. The statute also has changes in the contents of a complaint, and part of this is related to the new notice, but part of it goes beyond that. So we've got new information here about the content of the complaint. Again, if it's non-payment of rent, a detailed itemized accounting or statement listing the amounts. And that could very well just take the detailed information that you put in 14-day notice and put that into the complaint. So if you do a nice detailed notice, which I think you ought to do, then you can just transfer that information into the complaint if you need to file a complaint. If you're alleging breach of lease, you have to be similarly specific about the basis of the allegation, kind of dates and nature of the conduct, and the like. Now, I've always felt that that's what landlords ought to be doing. When I've represented landlords, I've advised them, don't hide the cards here either. Say who did it, when they did it, what it was, and how did it violate the lease. Put the cards on the table. The law didn't specifically say that in the past, although it did say that you have to specify, you have to plead the facts which authorize recovery of the premises. So when I advise landlords, I say, be detailed. When I was representing tenants, sometimes I got cases dismissed when they didn't go into much detail. I saw complaints that simply said, we're evicting for violations of the lease. Doesn't say what provision, doesn't say what date, doesn't say who did it, doesn't say what they did. So now the law is clear that that's what landlords need to be doing. If there's a notice that's been given, the notice needs to be attached. If there's information about attachment of the lease as well. Yeah, and you can read this. I don't want to get bogged down in just reading everything to you. I assume you all can read. So let's go to the next slide. Okay, the summons has been changed to have a little more information and in it. And that doesn't really apply to those of you that aren't court staff. I think the big change in here is being more information about how hearings are done. I think the courts have been pretty good about that in the Zoom era of saying, this is how we're managing our court hearings. I'd say the big change here is the summons now will have to have information about getting legal assistance and financial assistance. So everything we've been talking about so far, note subdivision 5 here. The court must dismiss and expunge an eviction that fails to comply with this section. And so we're talking about everything we just talked about is very important that landlords comply with them. And again, don't play games with it. I mean, be detailed and be transparent. Follow this to the letter. If you're on the tenant side of the equation or your attorney representing tenants, you want to hyperanalyze this and see that the landlord is compliant. Next slide. Okay, this statute, there's some deleted language here that I don't think is all that consequential. Essentially, by having the new 14-day notice in the last statute, it kind of made sense to get rid of the 14-day notice in this statute. Now, they're not exactly the same type of notices because they appeared in different statutes and they had slightly different interpretations. And so if this one stayed, I think it would have been real confusing to have both of them there. A question I get about the 14-day notice is, well, how does that connect with ordinances that have a notice requirement for non-payment of rent? And I think because of the supremacy of state law versus local ordinances, if the local ordinance has a shorter time frame, like 7 days or something, I think that this would trump that 14 days. If the ordinance has a 14-day notice, as Minneapolis and St. Louis Park does, then if I were representing a landlord, I would make sure that my notice was compliant with both. Look at the Minneapolis ordinance. If I'm in Minneapolis, St. Louis Park, if I'm in St. Louis Park, I'd look at the requirements for that notice. I'd look at the requirements under state law, and I would make sure that my notice all those. If it's a city that has a longer notice, I think it's Brooklyn Center that has a longer notice, like a 30-day notice, then the way I would look at that is that if you're covered by that longer notice, you would need to give the longer notice, but you'd have to have content that matched both the ordinance and matched the new law. This is a little bit outside of our topic today, but we've had some conversations in the past about the CARES Act. The CARES Act is a federal law that went into effect in 2020. A lot of that law is not in effect anymore, but one part of it that still is the requirement that landlords of covered properties give a 30-day notice. Covered properties includes almost all, I think all of the alphabet soup of subsidized and public housing programs, but also properties that have a federally backed mortgage. And so if I were representing a private landlord in an eviction case, I would want to figure out, does that landlord have a covered property? I want to find out if the mortgage is federally backed or if it's in public or subsidized housing. If it isn't, then the CARES Act doesn't apply. But if it is, then it does apply. And so in that situation, I would be saying to a landlord client who's covered by the CARES Act, you have to give a 30-day notice, but you have to give the content in a non-payment of rent case that's required by our new law. So, okay, let's move on. So service of the summons, this first part is not a big change here. It's just a deletion of that line, may be served by any person not named in the action. That's taken out. So for the purposes of how, who serves a summons and complaint, you just then look to the rules of civil procedure and specifically Rule 4, the Minnesota Rules of Civil Procedure. Next slide. So here's the bigger change down in 2.3. Plaintiff's attorney has communicated to the defendant in an eviction hearing that an eviction hearing has been scheduled, including the date, time, and place, by at least one form of written communication the plaintiff regularly uses to communicate with the defendant that have a date and time stamp. Okay, so a lot of landlords and tenants communicate electronically. They might communicate. It's a little bit of a generational divide. People that are more in my age range, I'm 68, probably more likely to use email. When you get to people that are younger than me means virtually everybody, then you're maybe using text, maybe using Facebook Messenger or a different chat vehicle. So what this says is if there is another kind of form of communication that the landlord and tenant are using, that the landlord or landlord's attorney needs to communicate the date, time, and place of hearing of the eviction hearing that's coming up. Okay, next slide. Okay, there have been a number of changes in pretrial procedure. The big change here is the courts now have more flexibility to schedule hearings when they need to. And I think this became acute in the height of the pandemic. Well, maybe less then, but coming out of the pandemic, well, I think we're still in a pandemic, but coming out of the height of the pandemic, we had a lot of cases being filed, and we had a legal structure that was really saying to the courts, you need to schedule these cases within 7 to 14 days, and generally you shouldn't be continuing them more than 6 days. And the courts, I think, did the best they could with a lot of cases coming out when the pandemic started to slow down. It would have been great if the court could have just hired a bunch more attorneys and referees and judges, but they didn't have the funding to do that. So they simply had to deal with the flow of cases with the staffing they had, which meant that a lot of cases weren't heard in the time frame that was set out in the statute. And I think this kind of gave rise to a conversation that the courts need to have some flexibility in how they schedule. There certainly are some cases that are going to be more complicated, and perhaps there needs to be some time for discovery. Maybe that case gets scheduled a little further back, a case that is more routine. I would think most of the non-payment of rent cases probably would be filed or would be heard earlier than maybe the breach of lease cases, but at least would give the court the ability to have that conversation with the parties, have that conversation with counsel, and figure out what's the best way for scheduling. Next slide. This slide is getting at, again, that issue of tenants paying rent into court. And what I saw often in eviction cases for non-payment of rent, but the tenant was raising a habitability defense, and a judge or referee would say, okay, tenant, the landlord says you owe $1,000 for December. You have to pay that into court before I give you a trial. Even though the tenant is saying, I don't owe the 1,000 or all of the 1,000 because I have this defense. And the Fritz case never required this. The rules of general practice didn't require it, but it became kind of this perception issue that was the state of the law. And, when I represented landlords, I did not make that request for that because I didn't think that was the state of the law. And when I represented tenants, I argued against having to pay essentially back rent into court. I've done other types of litigation. It's pretty rare in any litigation where if A sues B for $1 million, that B would have to pay $1 million into court to put on defense that it doesn't owe $1 million. So anyway, so this is another one of those changes. I talked about one of them earlier with combined cases that took out paying rent into court language in there. And this one's a little more specific. Basically talks about paying rent, kind of future rent into court as it accrues, but not the back disputed rent. So for some judges and referees and landlords, this is going to be a big change in practice. And I think this is a good thing. I don't think that due process should have been hinged on the ability of the tenant to pay disputed rent into court. Next slide. This repeal is the repeal of the statute that limited continuances. And this kind of goes hand in hand with the earlier slide, giving the court more flexibility on when it hears its cases. Next slide. Okay, judgments. There's a change here in the existing law said that if a tenant wanted to get a little extra time to move, the tenant could ask the court for up to 7 days to move, but would have to show that it would be a substantial hardship if the tenant had to move earlier. And that language has been removed. And essentially what this says now is that the court will give tenants 7 days to move unless the exception applies. The exception would be behavior that seriously endangers safety of other residents or intentionally or seriously damages the property. Next slide. Motion to vacate is now specifically authorized by statutes, and an order denying a motion to vacate is considered a judgment for the purposes of appeal. There have been some judges or referees that have taken the position that since 504B never discussed a motion to vacate a judgment, that it's either not available, and it was there's conflicting case law about if you do that motion to vacate a judgment, what's it do to your appeal time frame? And I always thought that both sides have a right to do a motion to vacate a judgment under Rule 60, the Rules of Civil Procedure. There's no exception there. And I always thought that if you had the right to do that, then your appeal time ought to be based on the decision on that, not to have that clock running while you're doing a motion to vacate. And so this will, in my mind, clear that up. Next slide. Okay, so for the content of the summons, now we have language here about contacting legal aid and getting financial assistance. Next slide. Appeal bonds. So this is another change in what in tenants having to pay rent into court. So there, when you appeal, you have to comply with appellate laws and also Minnesota statutes. There's requirement of doing what's called a supersedious bond. And the purpose of that bond is to protect the respondent to the appeal from any financial hardship that might be the result of the appeal. So the example is, let's say, well, in eviction cases, for instance. So let's say the landlord wins and the tenant appeals. The purpose of the supersedious bond order is to basically stop the eviction pending the appeal. So you don't have to do a supersedious bond in an appeal. But if you want to stop, if you want to halt the effect of the district court order, you need to do one. Okay. And let's say an eviction appeal, Court of Appeals might take about, maybe 9 months from kind of start to finish. And so some judges or referee would say, okay, tenant, you have to pay, 9 months rent front right now, because the risk to the landlord is this appeal goes on for 9 months and the landlord is ultimately successful, the landlord wouldn't have had that rent. I've always argued that the landlord is adequately protected, that the tenant continues to pay rent as it accrues actually to the landlord. The landlord's better protected than the tenant having to pay that into court. And again, it was one of these issues of, in my view, denying due process if you can't come up with the money. And so this change in the law basically says the court may not require a bond including back rent or late fees or disputed charges. So essentially what the court can do is say, pay your rent as it comes due. And that will protect the landlord. Next slide. And this is just another change consistent with the last one. So next slide. And this one is too. So next slide. And What this one did is it kind of reduced the exception where the appellate bond rule would not have applied. And so what we just discussed is going to apply in more cases than it would have previously. Next slide. And the effective dates here, January 1, 2024, for expungement. And the reason why I'm moving through the appeal stuff fairly quickly is I think it's pretty readable, and also it applies to such a small number of cases. You know, very few eviction cases are appealed up to the Court of Appeals. So next we're moving on to expungement, and these laws are effective January 1, 2024. Okay, so the first change here is statutory expungement had a three-part test for a discretionary expungement. And that was that the court finds a case sufficiently without basis of fact or law, which include lack of jurisdiction over the case. So basically kind of a merit test on, do the landlord's case have weaknesses in it? And is it clearly in the interest of justice for the tenant to get an expungement? And is that interest outweighed by the public interest? So you had a three-factor test there. And I've been talking a lot in eviction cases today about tenants and landlords. You can have other parties in an eviction case. You can have a mortgagor and a mortgagee. You can have a contract for deed vendor and a vendee. It's a really small number of the eviction world. So, and I'm guessing most of you that are on the meeting today are either landlords or tenants, or people that work with landlords or tenants. So that's why I'm maybe being a little less precise in my language. Okay, so what this change did is remove the merit test. So if the court is going to look at a discretionary expungement, it's simply weighing the interests of justice, the interest of the tenant, and the interest of the public. This will actually bring discretionary expungement in line with the common law of expungement. So for those of you that aren't attorneys, common law are principles that have been put together by the court in various areas of law. And so there are court decisions discussing what are called inherent authority or common law expungements. And there, the test has simply been, what's the interest of justice and the public interest. So now discretionary expungement under the statute is really going to match the common law. Next slide. And then the other big change here is that the legislature greatly expanded the categories for mandatory expungement. So the sections that are on this slide are what were the ones where mandatory expungement applied. And these changes came into effect in the late first decade of the 2000s as part of the mortgage crisis. And it gave the court the power to expunge cases in sort of the mortgage foreclosure world, where either the defendant had left the property or the defendant hadn't been in any fault. And so this got used a bit back in that time frame, not so much since then. So we'll get to the next slide in a moment, but the change on this slide is it made it clear that the court, when it has a mandatory expungement, should do that without anybody asking for it, but the court simply does that. So now let's move on to the next slide. You see the expanded categories. So if the defendant prevailed on the merits, so tenant one, let's back up a little bit. Back up a little bit. There we go. If the defendant prevailed, in other words, won the case, if the court dismissed the case, so in other words, the defendant won, if the parties reached an agreement to expunge the case, or 3 years after the eviction was ordered, or on the motion of the defendant, so this last one would require the defendant to ask, if the case has been settled or if the defendant fulfills the terms of the settlement agreement. So one of the reasons to have mandatory expungement and not requiring the tenant to ask for it is if the tenant hasn't filed anything in the case already, filing a motion for expungement, a written motion, would require the tenant to pay a filing fee. And certainly some tenants are eligible for those waivers, but there are a lot of tenants that wouldn't. And so that's one reason, but also to get the court into the practice of doing expungement automatically in one of these categories. So the only outlier here is if the case is settled and the defendant fulfills the terms of the settlement, well, that one really requires the tenant to say, that I did, because the court's not going to know at the time that it approved the settlement, has the defendant fulfilled it. Next slide. Okay, there also part of this law was to make evictions files private until final judgment, but the Supreme Court invalidated that in an order in August. That order, in my view, doesn't indicate resistance of the Supreme Court to the concept of having evictions being private until judgment, but the court and separation of powers analysis was saying that's for the court to do, that's not for the legislature to do. The order makes reference to the rules of public access to records of the Minnesota Judicial Branch. So there is a set of rules out there, just like we have rules of evidence, we have rules of civil procedure, we have rules of public access to records. And so I think the way to kind of tee up this specific issue here would be to make a request to the Supreme Court to amend the rules of public access to records of the Minnesota Judicial Branch and see if the court can be persuaded that this is a good policy goal. But for the time being, this subdivision 6 of this law is not in effect. Next slide. Now, I wanted to talk a little bit about different types of claims that now can be raised in eviction cases that weren't available earlier. Okay, so far we've been mostly talking about process and procedure. Okay, so there was a change in the privacy statute, and I know that was discussed at another one of our seminars. And one of those changes was to make clear the amount of advance notice that needs to be given and time window for the visit to the tenant's apartment. And that's what's covered in this slide, effective January 1, 2024. Let's get to the next slide. Now, what this slide does is the current law said that if the tenant wanted to litigate a privacy violation, the tenant had to do it under the statutes that are listed there. And those aren't the eviction statutes. Okay, those are the statutes governing cases that tenants file against landlords over habitability issues. So the first big change here is change shall to may. So that means the tenant may do that, but that doesn't. So now it basically says you may do it that way, but because the word may is there, that basically implies you could do it a different way. Which means, in my view, you could raise it in an eviction case as a defense. But I think what makes that even more clear is a violation of the privacy statute is now a violation of 504B161. And under the Fritz case, where the court held that the predecessor of 504B161 could be raised, violations of that could be raised defensively in an eviction action. So when you pile this all together, it means that a tenant can now litigate privacy violations as a defense in an eviction case. And you can see that the penalties for violations have increased. It went from 100 to 500. And there's also an attorney's fee component as well. Next slide. Can I have a drink of water here? All right. So another change to law that was discussed in early one of our seminars is now landlords have to provide 68 degrees heat October 1 to April 30, unless a utility company requires and instructs the heat to be reduced. We talked about this in detail in an earlier seminar, and as Rachel will mention when we get done, you can find the recordings and slides from all of our earlier seminars from Homeline website. Okay, this is this new requirement is in 504B161. And since under the Fritz case, you can raise violations of 504B161 in response to, in defense of an eviction case for non-payment of rent, means that if a landlord is not providing heat at this minimum temperature, that the tenant could raise that defensively in an eviction action. Now, because it's in 504B161, the tenant would be able to raise it in other actions as well. Next slide. There's a change in 504B171. There are actually two changes. We'll talk about one of them now. We'll talk about one in just a few minutes. This one is dealing with crime-free lease provisions. So crime-free leases, and I could talk for a while on this, but I'll try to settle down and not do that. Crime-free lease provisions came out of the kind of war on crime movement in the 1990s. It's kind of a cottage industry of consultants that went around the country and told cities that you should have provisions in here in your ordinances requiring landlords to evict tenants that are violating the law, so you can kind of clean up your town or city or suburb or whatever. And what we've seen over the years is in some cities, the cities have basically used these laws to force landlords to evict tenants for the conduct of household members that they don't like, that maybe are criminal, maybe not, maybe they're a nuisance, maybe not. I certainly had cases where the 16-year-old kid shoplifts at a store a mile away, and the city says, the landlord, you have to evict this household. The landlord's saying, I don't want to evict this household. They pay the rent, they're fine on site. And the city would say, often it would be the police, would be saying, well, because of our ordinance, if you don't evict this family, we're going to yank your rental license. And so I had cases where landlords would file the case they didn't want to file because of that. And so what this change does is it basically says that landlords can't evict tenants for or impose penalties, conduct off the property, with a couple of important exceptions that involve crime of violence. That the conduct off property would constitute a crime of violence against another tenant, tenant's guests, landlord's employees, okay, regardless of whether that person's charged or not. So in other words, this is supposed to get at the tenant who goes off-site and does something of violence to someone from the property also off-site. So to not kind of create that window for a crime of violence. So landlord can evict for that. Also, conduct that results in a conviction of a crime of violence against a person unrelated to the property. So the tenant's off the property, is convicted of a crime of violence against someone unrelated to the property, and the landlord is now thinking, I don't know if it's safe to have this person on the property. The landlord could then evict that person or impose a penalty. This doesn't limit in any way the landlord's ability to evict tenants that are involved in criminal activity or lease violations on the property, but essentially gets landlords out of the business of having to police the conduct of tenants and household members out in the community. Nothing here prohibits the police and the city to prosecute crimes that occur anywhere. But what we were seeing is that for certain types of offenses, some cities were essentially not using the criminal justice system and essentially putting pressure on landlords to evict tenants for the conduct of household members that the city weren't prosecuting under the criminal justice system. This is one of the few laws that regarding landlords and tenants that doesn't go into effect January 1, it goes into effect June 1. Next slide. This change in recovery of attorney's fees. There's a Court of Appeals decision that's said that, okay, what the statute says, if a landlord has an attorney's fee provision in a lease, that this law basically applies it in a mirror image way to the tenant. So if it says that if a landlord files an eviction case landlord gets attorney's fees, then this statute would say that the tenant has the same right as well. So if the tenant wins the eviction case, they would get the attorney's fees. There was a decision by the Court of Appeals that said that this didn't apply to dismissals. It only would apply to victories on the merits. Even though, the test for costs, statutory costs, includes a dismissal. So by this cross-reference here, what this means is that if a tenant wins a case based on a dismissal or gets a judgment on the merits, and the landlord has an attorney's fee provision in the lease, that would apply to the tenant as well, which means that the tenant would have a motion for attorney's fees against the landlord. There's a Court of Appeals decision saying that even if the tenant is not being billed attorney's fees, the tenant would be able to make the request for the tenant's attorney at the billable rate of that attorney. And that goes into effect January 1, 2024. Slide. Getting kind of close to the end here. Okay, you might have heard that we've got some new laws related to cannabis, and there are a couple of them that are specific to evictions. We talked in detail about the cannabis laws during the summer, might have been in July. And again, you can find that recording and also the slides at the Homeline website. And Rachel already put that in the chat. So one change is an expungement. I think this one is not going to have a big effect. I think the next one's going to have a bigger effect. The court shall order expungement in what I view as a fairly limited set of cases. If there's a violation of 504B171 or another breach claim, and if the tenant could get an expungement under the criminal expungement statute, or if the breach was based solely on possession of marijuana or cannabis. I've been doing this a long time. I probably have 11,000 farmer clients, I'm guessing. The number of cases I had that were specifically based only on possession of marijuana would probably be a handful. And so I think this probably doesn't have a big effect. There was no effective date listed here, so effective August 1, 2023. Next slide. This is a bigger change. So we just talked a few moments ago about change of 504B171 related to crime-free ordinances, crime-free leases. Here's the other change. And this one didn't have an effective date. So this one's already in effect August 1, 2023. So 504B171 till now has been saying that both sides, landlords and tenants, have this implied agreement. So whether they've said it or not, it's part of their agreement. And their agreement was to not unlawfully allow controlled substances on the property. Okay? And so anything that was essentially illegal under Chapter 152, marijuana all the way up the list, would be an evictable offense. So what's changed here is, one, the word unlawfully has been taken out, and there's a specific reference to Chapter 152. So what that means is legal possession of cannabis under Chapter 152 is not a violation of 504B171. Okay. The other big change is the landlord can't prohibit a tenant from legally possessing cannabis products, hemp edibles, low potency hemp edibles, and hemp derived consumer products. Okay. And kind of continues on, with the exception being essentially vaping and smoking. So a landlord can prohibit smoking of marijuana, vaping of a marijuana or cannabis product, but the landlord can't prohibit the tenant from, for instance, possessing edibles that this definition. Okay. Now, there's a whole lot more in the cannabis law, related to plants and things like that. And I don't have time to talk about that now, but if you want to go back and kind of learn all the ins and outs of that, and that was not a reference to the Big Lebowski, maybe it was, go back and look at the cannabis seminar from the summer. Next slide. And we are sitting at questions now. So we've got a little bit of time for that. Let
Yeah.
me know what you got.
Well done, Larry. That was a lot of talking, for a long time. So thank you very much for all of that information. We got a little bit of bonus material as well with some of the other laws that are going to be coming into effect coming in January as well. So thank you for that. Um, so we got a couple of questions that came in pre-submitted. So I'll go through some of those first. Some of them are not necessarily particularly applicable to this particular presentation, so I will skip those and go to the ones that came in today during the presentation and then kind of come back to those other ones as we have time.
Sounds good.
Yeah. So again, if you have questions that have come up through anything, please put them in the Q&A just so that I don't miss them. I would really appreciate that. And again, for all the folks, these are going to be available. The recording and the slides are going to be available on HomeLime's website in a few days. So as soon as we actually get everything in the cloud, I'll sort it out. Okay, I've stalled long enough. So our first question is from Christina, who is an attorney. And they're wondering, will the changes be for all counties or will provisions vary from county to county?
Everything that we discussed is statewide and will apply to every county in Minnesota.
All right. Michael it was asking about this eviction policy in Minnesota. I think that was for the last hour or so what we've covered. So let's see here.
While you're looking at that, I'll let people
Yeah.
know that if I'm stumped at all, I will check in with Santa and see if he can help me out.
He does know all. He sees everything, right?
Yes, he does.
So Nicole, who is also an attorney, is wondering about evictions based on utilities bundled into rent as other fees. What about
Yeah,
those?
that's an interesting question. There's a little bit of conflict in the case law as to whether utilities are appropriately raised in a non-payment of rent eviction case. And so we don't have a clear answer to that on that. I think a lot of landlords do it. I think a lot of tenants, especially unrepresented tenants, don't defend against it. The changes that we've discussed don't answer that question.
Fabulous. All right. Next one I've got is from Rafito, who's a service provider, I believe. And they're wondering about so tenant using cannabis in an apartment that's legal in Minnesota, but the landlord wants to hold them to a no drug use term in their lease agreement.
Well, under the change to 504B171 that we just discussed, the landlord can't prohibit the use of the listed cannabis items that are there. And so a landlord would not be able to have a completely no drug policy. The landlord can, and the tenant, the implied covenant of 504B171 is essentially a no drug policy for anything other than cannabis of illegal drugs. So for instance, 504B171, the tenant and landlord both are agreeing to not have controlled substances, to not allow controlled substances on the property. So that would mean that both the landlord and the tenant, if they have, for instance, cocaine on the property, are in violation of that. And so a landlord can have a policy that's consistent with 504B171. And actually, the landlord wouldn't really have to have it because it is a violation for 504B171 to have a controlled substance basically above cannabis products. Now, if the landlord wants to prohibit smoking or vaping, the landlord can do it. The landlord doesn't have to do it, but the landlord can do it.
Right. Fabulous. Thank you. Okay, the next one is from Kim, who's an attorney as well. And they're wondering, how do tenant advocates feel about having a tenant's lease and ledger filed with or into eviction cases?
Oh, well, I don't know that I can speak for everybody, but I think it's a benefit to both landlords and tenants to have transparency. Um, when I've represented landlords, when I filed cases, I want to have those cases buttoned down. I want to know exactly what I'm going to present, and I want court to know what I'm going to present, and I want the tenant to know what I'm going to present. So before all this, if I was representing a landlord, I didn't represent a lot of landlords, but I represented some nonprofit landlords. And if we were doing that type of case, I wanted that kind of detail there. On the tenant side, I always wanted that kind of detail. I mean, what are you really saying I owe? Because I might dispute it more if I know more. Let's say I'm looking at a charge of rent over, the last 3 months of $4,000, and it's not broken down, and I know my rent's $1,000 a month. Where's the extra 1,000? And what the new law is going to require is breaking that down. And I think it's gonna be helpful to landlords and their attorneys to go through the thought process, putting down on paper what the real deal is. And it's going to be good for tenants to see what the real deal is, so tenants can decide, do I want to fight this case or do I want to negotiate? So I really don't see a downside here.
Yeah, just the only thing I can think of that might be potentially problematic, and this is problematic with any eviction filing in this situation anyway, is if the tenant themselves is a save at home participant, then having like their name and address and on the public record is problematic, but there are already workarounds for that sort of thing, filing things confidentially, but it's just, making sure that the attorneys or the landlords are following those proper steps anyway, that if they know that their tenant is a participant in that program. Um, yeah, otherwise that's the only thing that kind of came to mind as a, concern sort of thing. Um, so Sana asks, they're a tenant and they're asking a question I'm going to kind of elaborate, add on to a little bit, but they're saying, um, well, it's not actually a question. They're saying a landlord doesn't have to let you cure a violation or a breach of the lease. They can still file an eviction without you knowing. So is there any notice requirement at this point for like breach of lease evictions?
Well, there is in Brooklyn Center, there's a 30-day notice requirement. In public and subsidized housing, uh, most of the programs require a notice for breach of lease. In manufactured home parks, there's a notice requirement for breach of rules. And also all those programs, so manufactured home parks and public and subsidized housing, most of them have been dealing with notice requirements for ages, and they've gotten along just fine with it. It does require maybe a little more advanced thinking, so that if you have a non-payment of rent case, and you want to file relatively soon, then you give your notice relatively soon when the rent is due. And so this won't be a big change for these other providers. I should say that in the manufactured home parks, the manufactured home park law is a 10-day notice for non-payment of rent. And this new state law is a 14-day notice. So there's maybe a question, well, which one applies? In my research, I think the 14-day notice applies because it's the most recent announcement by the legislature on the topic. But I wouldn't be surprised if there's a case at some point where the courts have to figure out which one applies or not. But if I were advising a manufactured home park, I would say, don't chance it. Give the 14-day notice. Don't give the 10-day notice, and give the other side the ability to say, well, wait a minute, you gave me the wrong kind of notice.
Mm-hmm. And yeah, especially for like manufactured home parks, they've got even longer notice. They have a notice requirement for like breach of the rental agreement, sort of thing as well. I believe it's 30 days. No, I'm not.
Yeah.
That chapter of law is something that I have to look up every time that I get a call about that stuff. So,
Yeah, in the
um,
manufactured home park world, there are kind of different time parameters for different types of notices.
mhm,
And also in public housing, there are different time parameters for different notices.
gotcha.
One,
Okay.
one clarification on that, though, is that with the CARES Act, public housing has to give a 30-day notice, not the earlier, shorter notices that it had to give pre-CARES Act.
All right. Fabulous. So then let's shift over quick to the questions that were submitted during the webinar. We have about 15 minutes left, so we're doing just fine on time. So then we'll try and go in order. Andrea is wondering, when you say owned by public housing authority, does that include when the HRA has done a RAD conversion and the owner is an LLC or something like that, which is overseen by the same HRA board of commissioners, but isn't necessarily specifically owned by the HRA?
I think, so now we're talking about the public housing right to counsel for breach
Yes,
of
I
lease
believe so.
cases.
Yes.
And I think it would not apply. I think it would only apply if public housing is owning and operating it. When you do what's called a RAD conversion, which is kind of getting into the weeds of the public and subsidized housing world, you end up with a different ownership entity running the property. So I think it would not apply there.
All right. Thank you. And oops. Um, as with as I've said in every one of these webinars, and will continue to say, all of these laws are new laws. We don't know, this particular one, the right to counsel, has been in place for a couple months, but as Larry said during the presentation, there aren't a lot of cases where it comes up. And so it just hasn't happened in a lot of instances yet where there's some question about whether the tenant has that right to access that counsel or not. Um, but we don't know exactly how this is all going to play out. It's going to be, you know, a couple weeks from now, we're going to start seeing things roll in, but it's probably going to take a while for those, court interpretations, the judicial interpretations, lawsuits have to be filed, that sort of thing. So we are making educated assumptions about how these are going to play out based off the language and the experience with the courts and things like that. But again, we don't know for certain.
Yeah, and I mean, and part of that goes back to what I was saying earlier. I mean, in my view, I thought the Fritz decision never provided the authority for courts to order tenants to pay back rent in court. But I don't run the world, and a lot of that has been happening over the years. And so, we can definitely make some educated analysis of what's going to happen under these new laws. But they're going to come up in a lot of different counties in front of a lot of different judicial officers. So we may see some inconsistent rulings, as we do in all areas of the law.
Indeed. All right. Gabriel, I think we're jumping up forward to the heat portion, requirements. They want to know, and I'm sorry, Gabriel, I typed in answer by writing instead of answering live. So your question may have been removed from the Q&A from your site, but they're just asking, what about when an HOA controls the heat? How does that impact the heat requirement?
Well, if there is a landlord-tenant relationship involved, then it applies. And this raises a good question. I've felt for a long time that so HOAs are homeowner associations, so it'd be like condos and townhouses and things like that. I personally have felt that owners of their spaces have had less both procedural and substantive rights as compared to tenants. And in my own view, I'd be nice to see that clarified and expanded at some point, but that's not what we do at Homeline. And so if there is a tenancy involved in a condo, so let's say the condo owner is renting out the condo to a tenant, then that condo owner would have the responsibility to make sure that there's 68 degrees heat there. Now, between the condo owner and the homeowner association, this law does not apply to that.
Excellent. Okay. This next one, I am not 100% clear exactly on what the question is, but this is from Anonymous. I'm going to read it out. If this is your question, you have some clarifying words that you can help me out with, that'd be awesome. But they're saying, what is meant by provide? This was given in the heat section, and so I'm wondering, they're saying more along the lines of like energy efficiency, weatherproofing, or actually providing the electric gas utility.
Well, what the specific language is, and if you go back to slide 44, it says, quote, to supply or furnish heat at a minimum temperature of 68 degrees Fahrenheit from October 1 through April 30, unless the utility company requires and instructs the heat to be reduced. So what this is really talking about is providing heat sufficient to sustain the temperature in this time period. Now, the landlord could potentially accomplish that by using energy efficiency tools that allows the landlord to provide less of the substance that creates the heat as long as the heat's maintained. So it really talks about kind of the goal is 68 degrees. Now, if the landlord can make, basically supply the heat to keep it at 68 degrees and spend less on that substance, whether it's gas heat, water or electricity or propane or whatever, if they can spend less by investing in energy efficiency, this thing doesn't say anything about that. The end result has to be 68 degrees available to the tenant. Now, if the tenant controls the thermostat and wants to set it down to 65 degrees, that's not a violation of this. The tenant has to have the capability of existing in their unit at 68 degrees heat, and the landlord is responsible for making that happen. And the landlord can look at a variety of mechanisms, including weatherization and the actual provision of the substance that produces the heat to comply with this.
All right. Fabulous. Okay.
And we did go in more detail about this in one of our earlier seminars.
Yep. Yeah, one of our other housing attorneys, Matt, went into a lot of detail about all this. So, and you can watch his fabulous heat video as well, which I'm going to promote until the end of time because it's informative, but also absolutely ridiculous and good for a laugh. All right.
Yeah, in case you all didn't know, we actually have bona fide actors within the crowd at Homeline, including our own Rachel.
Oh, yes, of course. I mean, aren't most attorneys actors in some way, shape, or form?
Some better than others.
Fair. All right. So Anonymous, you had mentioned briefly earlier CARES Act, and so Anonymous would now like you to expound a little bit on your thoughts of the interaction between the 14-day notice and the 30-day CARES Act notice.
Well, again, the CARES Act only applies to what are called covered properties. So public and subsidized housing, the whole alphabet soup there, and federally backed mortgage properties. So if the CARES Act applies, if I were a landlord, what I would do is for a non-payment for my cases, I would do, and there's some disagreement about does the CARES Act apply only to non-payment of rent cases or apply to breach of lease cases. The cases that have been litigated that I've seen have all been non-payment of rent, but I haven't seen any language in the notice provision in the CARES Act that limits it to non-payment of rent. So if I were advising a landlord of a covered property, I would say, give a 30-day notice in all cases, breach of lease cases and non-payment of rent cases. If it's a breach of lease case, there's no content requirement in the CARES Act, simply a timing requirement. So you got to give a 30-day notice. But if I were governed by, let's say I'm a public housing authority, then I would give a 30-day notice, and the content of that notice I would take from the Public Housing Authority regulations. Okay. Now, if I'm doing a non-payment of rent case and I'm a covered property under the CARES Act, I would give a 30-day notice, but then the content would be based on state law, the 14-day notice requirement for non-payment of rent. So that content dealt with what's the total of rent, how do you break it down in a detailed way, information on financial assistance, who receives the rent, information on legal assistance, all that kind of stuff. So that content would go into my 30-day non-payment of rent notice. But if I also was covered, let's say I'm in public housing, or let's say I'm a HUD subsidized project now. So I would have to give a 30-day notice. I'd use the content from our new state 14-day notice law, but then I'd also look at the manual that covers my subsidized housing property. It's not that I'm a nerd about this, but it's HUD manual 4350.3, and it has some information in there on content. And so I would include that content and the non-payment of rent content. Now, to make it even a little more interesting, let's say that I'm a landlord covered by the CARES Act. I'm not in public or subsidized housing, but I'm in Minneapolis. Okay. So now the CARES Act says I got to give a 30-day notice. So let's say I got a federally backed mortgage. I'm in Minneapolis. So CARES Act says I got to give a 30-day notice. I would have to give that notice for both breach of lease cases and non-payment of rent cases, in my view. Let's say it's a non-payment of rent case. The content would have to conform with our new Minnesota law on 14-day notice. It would also have to conform with the content of the Minneapolis ordinance 14-day notice. And there's a bit of overlap in that content. But what I would do is I would essentially match that content and give a 30-day notice. So hopefully that wasn't too long of an answer there, but when you are governed by different sets of laws, you have to kind of figure out how they can play nicely together. And for the most part, federal laws don't preempt state laws unless they're in a direct conflict. And so for the most part, you look at what federal law requires and you look at what state law requires. And if there's an ordinance, you look at what an ordinance requires, and you figure out how to meet them all.
No small task there.
Well, you know,
Right.
it's actually not a huge task.
No.
It just requires, in that last scenario, to be aware what's the Minneapolis ordinance, what's the state statute, take the language, come up with a template, put the language in there, and if the CARES Act applies, it's a 30-day notice.
Yeah, you only really have to do it once, luckily.
Yep.
So,
Yep.
all right. We've got 2:57 on my clock, so I don't know if you have something right after this or if you have a couple extra minutes to stick around after 3.
I can
But
go to about 5 after, and then I need to
okay,
go to another meeting.
not a problem. So I'm going to ask this next question. We've got 2 questions, actually, similar lines, but Mike, an anonymous person, Mike says, excellent presentation. So well done, Larry. They're wondering, with the new change in non-payment of rent cases, what is your estimate of how long it's going to take to evict a tenant who has not paid rent? So from giving the 14-day notice to first hearing to trial if necessary, then ordering the writ to processing the writ with the sheriff and actually scheduling the sheriff to physically remove the tenant.
Okay, so that's a little hard to predict because courts are going to have a little more flexibility in scheduling. But so right now, if the rent was due in the first and you file the case in the second, which a lot of landlords don't do, but let's just talk about fastest scenarios. Okay, so right now, if you file the case in the second, you get your case scheduled within 7 to 14 days. So I'm just going to pull out a calendar here and just kind of look off to my side here. So, or maybe I'll just pull one up on my computer screen so I can kind of follow. Say we're at December 1, which was a Friday, and rent wasn't paid. So I filed my case on December 4, and then the court would schedule a hearing within 7 to 14 days. So now we're looking somewhere between the 11th and the 18th. And so let's say I get my case scheduled in the middle. So we'll say like on the 14th. Now, if the tenant doesn't show and doesn't fight the case, then I get an immediate writ of recovery, and I can take it over to the sheriff that day on the 14th. Sheriff would probably deliver it on the 15th, and then the tenant would have to be out by the 16th. If the tenant wasn't out by the 16th, I could contact the sheriff on the 18th, schedule a move out. Now it depends a little bit on the availability of the sheriff, but let's say they can get to it by the end of that week. So then it would be the 22nd. And then as soon as I have that scheduled, I send a letter to the tenant letting them know that that's going to happen. Okay, so that's on the very fast end of the world. Okay, so let's say I had that hearing on the 14th and the tenant comes and defends it. It says, I've got habitability issues. I need to have a trial. So now the court's looking at the tenant's calendar, the landlord's calendar, and the court's calendar to figure out when they can do the trial. And, if you're in a county that doesn't have a lot of evictions, maybe that trial happens in a few days. But let's say it's a fairly busy county, and people's schedules are hard matching up. That trial might not happen to maybe the end of the month. And then once the landlord wins the case, if they win the case, so let's say that case is heard on the 29th of this month, and then the court takes it under advisement. Well, the court might issue a decision right away, or they might take it under advisement. They actually have 90 days to decide cases. Most judges and referees do it a lot quicker than that. Once the referee or judge has decided the case, if the tenant has asked for some time to move, the court can give the tenant 7 days to move, and then that process I just discussed with the sheriff comes into play. Okay, so now let's move on to January and see what happens. Okay, so let's say rent's not paid January 1, and I can't file my case January 2 because I got to give the 14-day notice. So I give the 14-day notice. I guess say I give it on January 2, so 14 days runs on January 16. If I haven't worked anything out with the tenant, then I file the case on the 17th. And so then the court's going to schedule that case. It's going to look at its flexibility in scheduling, but I think with a non-payment of rent case, it would probably be scheduled probably sooner than later. So I think the time frame starting on the 17th would be kind of similar to what I talked about with the time frame starting on the 2nd for this month. So I think what it does is essentially pushes things back about 2 weeks. Now, but the flip side is, let's say I never have to file that case because I give that notice on the 2nd, and the tenant and I have a conversation about, can we get emergency assistance? Can you get some help from others? Do I need to do some repairs? Is the place unaffordable? Do you want to move? And maybe we work something out so that by the time we get to the 17th, I don't need to file a case. So in that situation, I've actually, let's say the tenant moves out or I get paid. I've actually achieved a result sooner than I would have under existing law filing cases as we file them right now. So again, there are a lot of variables in what I just said. But I think what it does is that for the case that has to be litigated, I think it pushes it back about the same time frame as giving the notice. But I think it's going to lead to less cases. And if you're a landlord that didn't file cases on the 2nd, if you were the landlord that didn't get around to filing cases until a week after the rent is due, but now you give the notice as soon as you can give it, then the notice isn't really slowing you down that much.
All right. Thank you for that. Very thorough answer. All right. It's 3:03, so Wendy has a question that I think is a leading question potentially for if there's any amendments, perhaps minor corrections to the new laws that will be pursued in the 2024 session. And I know of at least one.
Yeah, there have been some that have spotted. I noticed in the cannabis area that there's some inconsistent things there related to landlords and tenants. We talked about the change to 504B 171 related to cannabis. It's in effect right now. There's another section in there that goes into effect, I think, March of 2025 that seems inconsistent with this change to 171. And I suspect that was because different people were working on different sections of this really large law. So I'm guessing that will be informed at some point. I would be shocked if there weren't any adjustments to what happened this year.
Yeah, I believe there was a typo in one of the eviction statutes as well. I'm trying, American Historic mentioned it in our big CLE on the 7th. That
Well,
is
also, I mean,
already
yeah, and also on the law related to disclosure of mandatory fees. The title to that law, I think maybe has the word prohibited in it.
hmm
And even though the statute doesn't prohibit, it just requires disclosure. And that was because two different proposals were kind of merged at the last minute and it didn't, nobody wordsmithed it.
sure.
So we might see some of that stuff too.
Yeah. So there's probably some stuff that will be adjusted a bit. And at least for Homeline's perspective, we will be going into kind of our 2024 legislative agenda next year. Upcoming, stay posted or stay tuned. We will let you know. All right, and it is exactly 3:05. So I want to say thank you very much, Larry, for all of your time and expertise. It's been really informative. I want to thank all of you for joining us today and asking all your great questions. Again, this will be up on our website in a couple of days, along with the PDF of the slides. We do have another webinar scheduled for January that's going to be covering the renter's credit and some changes that are going to be impacting that process. So please feel free to register for that. And if you are a tenant and then you've just got specific questions about your rights as a tenant, please give us a call at 612-728-5767. And thank you all very much. Have a wonderful rest of your day and have a great new year.
And
And
thanks to Santa too.
thank you for Santa as well. You have a wonderful, wonderful day. Bye-bye.
Bye bye.